Hello and welcome to another recording of Law Talk UK with Karen Ford-Wilson, the legal expert, and myself, Lee Licorice, the eager student, discussing the Coronavirus Act. And today we're focusing on the hot topic of back to work.
Yeah.
Karen, over to you.
Thank you, Lee. Sorry. Hello, I'm Karen Ford-Wilson. Not sure how I wear the legal expert thing, but I suppose it's at some level. Yeah.
Certainly more expert than me.
Okay. Well, legal advisor perhaps is a little bit more appropriate. Law teacher, legal advisor. Anyway, I'm gonna try and not waste time, and I'm learning every time that we do this to be more and more succinct, and learning, failing is part of learning, right?
Yeah.
But as we said before, we don't edit these, so here they are, and that's hopefully part of the joy. Stops it from being too dry. Back to work is something that's been on people's minds a lot. I'm sure you've heard people talking about that, Lee, and some people are very eager. Some people are really afraid. Some people are worried, and a lot of people don't really know what to do. What's the right thing to do? They're finding it very, very confusing. So I've had a fair few questions that have come in this week. I know we can't deal with everybody's questions sort of, in full, like legal advice. At the end of this, I'll give people some advice on where they can go to get further clarification and further advice, or you can come back with another question to me, but I'll do my best. So here we go. I'm going to start by talking about employers, and that's anybody who employs anybody to do a job. Now that includes people who have a permanent workplace. I think these videos are perhaps more appropriate for people with small businesses or medium-sized businesses at the most, and sole traders, because and I say sole traders, I mean somebody who is the only person running their business, basically. I say that because I think that large companies will probably have legal advice and so on. So I'm going to focus on that. So if that doesn't include you, I'm really sorry, having to choose.
Companies with people all the time.
Yeah, and also trying to kind of catch up in that everybody's questions to the best ability that I can. So if you are an employer and you are now thinking about going back to work and reopening your office, shop, business of whatever sort it is, the big thing that's really important now is that your health and safety practices and policies are really bang up to date. And I would advise anybody to be really, really thorough. I mean, that's generally good advice anyway. Often employers, especially small companies, or those with a high turnover of staff, who have temporary staff and that sort of thing. Sometimes you find those companies are not, I mean, this obviously relates to employees as well, can get something from this, but sometimes you find that those companies' health and safety policies have got little gaps in them and so on. It's all very well until something goes wrong. The bottom line is that in law you cannot exclude liability for negligence. And what that means basically is that if something happens and you were found to have failed to do or pay attention to something or give somebody advice or warning about something, and a court decided that you should have known or should have done something that you didn't do and you were negligent, you are responsible for whatever that injury is that happens to that person. And if that injury were, looking at it in the real extreme, I'm not trying to scare people about that, but if that injury were to be death, because, I don't know, maybe a rafter fell on someone's head or something, I'm being, as I say, extreme to illustrate the point. it may be that the person's family or someone else other than your person, obviously if they're dead it won't be them, comes after you for this. So even if you're friends with your employees, don't think that it doesn't matter, because if someone comes after you and if it does result in death and there's a link all the way unbroken from you to the end result, you are responsible for a homicide, an unlawful death. It's not murder, it's negligent act manslaughter, but that's pretty damn serious.
Yeah.
You know, and that's what can happen sometimes with people who are dangerous driving. But trying not to get too distracted, that is the real serious, like extreme level end of things. Of course, when it comes down to coronavirus, the biggest scare for everybody, the biggest fear for employers is, how do we define all these things? We don't yet know, and the guidance and the clarity is missing on what exactly the risks are and at what level those risks are and what we can get it from and what we can't get it from. You know, I heard somebody today saying that the advice was that if she sold a piece of fabric, if somebody touched the reel of fabric that wasn't sold, she'd have to wait 72 hours before she could touch it again. And she has a small shop, you know. It's crazy. I mean, in that sort of case, if someone touched a reel of fabric and could be certain and prove that they got coronavirus from that reel of fabric, you know, I don't think that she'd have been negligent if she was careful and took all safety precautions. But you can see how you could get yourself into a bit of a pickle. Yeah. So I'm going to try and put the line of reason in terms of what the law is through this. Okay, so the law on health and safety at work is the same as it always was. It's only different. It's you want to look at I've forgotten, I've gone through so many different acts here. Health management of health and safety at work regulations, I think that's 1996. And you've also got employment rights acts and things that come into that, but I'll talk a little bit more about that in a few moments. So you've got to be very careful. The legislation is still the same. The law says that if you employ more than 5 people, you have to record your risk assessments. Okay. I would recommend for anybody in this confusing situation right now to record their risk assessments regardless of how many people they employ. Right. And if you are an employer, or if you are a business and you are not employing people, you should still be doing a risk assessment if you're using premises or if you've got personal liability insurance or anything like that. And that is particularly going to be an issue when it comes down to entertainment, and that was where another question came from. You know, if you're creating a piece of theatre art, even digital art, whatever it is, if you've got people there working for you, or people who are coming across the premises that you are in charge of, your personal liability or business liability insurance could be void if you didn't do a proper risk assessment. Okay. Everybody who runs a business should have an idea of what I mean by a risk assessment. But essentially, just in case you don't, this is the most important thing. Okay, so what you have to do is you have to consider every risk that you can identify, reasonably be expected to identify. And that, again, should give you some reassurance when it comes down to coronavirus, because you can't identify every risk. You can't identify risks you don't know about. You can't be held responsible for that. Okay. But you should think about what risks there could be. And if you have employees, you should think about finding out enough about those employees to know, are they vulnerable people? You know, is there a reason why they might be more at risk than somebody else? And you need to identify that. You need to do the best you can to put hand washing facilities around. You need to do these things. You can find out what the guidelines are, and I'll explain in a moment why guidelines are more important than usual here. But you can find out what the guidelines are on how to make your place of work COVID safe on the gov.uk website, and there's loads of links to the relevant law if you want to look that up. Ordinarily, I would say, and I have said, if you've seen my previous videos, that guidelines and guidance is advice, it's not law. But when it comes down to things like risk assessing, it kind of becomes embedded in law. It becomes part of the law because it's the difference. It's your evidence as to the fact that you considered all of the known risks. And generally, it's accepted that the guidelines are about that.
Yeah.
So the regulations will give you the law and the previous, employment laws that you would have always relied on. They still exist. They're still as they were. It's just that coronavirus is another risk. And that's a kind of perhaps a clearer way to look at it. Instead of thinking to yourself, oh my goodness, what are my responsibilities with regard to coronavirus, and everything's changed and the laws are all different, and you could be forgiven for feeling panic stricken like that. Take a sort of a step back and say, what would I do? What would my obligations be with regard to keeping people who come into my business either to work or as customers, because you're responsible for those as well, or as paying guests or whatever, people who have contact with your business and your premises that you're on at that time, even if you're renting your premises from somewhere else. What are your responsibilities? How do you keep people safe? And coronavirus is just another risk.
Yeah. You mentioned the entertainment industry.
Yeah.
What would happen? I mean, is it possible to say, let's say you have the public coming into your venue because that's part of your business. Would it be possible to get them to write or get them to sign a disclaimer saying, like, I'm entering here at my own risk? I recognise that the company has taken all the appropriate actions possible, but I'm still going to enter here at my own risk. Is that possible?
Well, there's two sides to that. I mean, my instinct is that not really, in the sense that, like I said, you can't exclude liability for negligence. So getting somebody to sign a disclaimer and say, I'm taking my own risk, doesn't exclude you from being responsible.
No,
but
I see that. I mean, you still take the risk assessment, but then you also cover yourself a little bit more, saying, if you're going to enter here, there's obviously a risk, because you wouldn't need a risk assessment. So this is what we've taken.
That's part of the risk assessment process, and that's the other thing. Thank you, you've reminded me there. That's the other thing for people to be aware of when they're doing risk assessments, is that you should put your risk assessment. You should make your risk assessment public. In fact, I mean, you're not obligated by law, as I say, if you're a really small company or if you're a sole trader. But I would say always make your risk assessment public. So record it properly in writing, put it on your website or whatever. Put it somewhere people can find it. Also, with regard to coronavirus and risks for your employees or for people who cross the premises, you are legally obligated, if someone's coming into your business, to display the coronavirus risk signs, hand washing, give people indications to where to go. And it's recommended that you would mark out distancing where that applies on the floor. Now, if you were a producer or an artistic producing director or something, you would be looking to mark out those spaces as much as you could. But if you're looking to put a performance together, you're going to have people working closely together. If you're going into rehearsals, you're going to have people working closely together in most cases. Again, look at, is there any way of doing it remotely? Most of those things there isn't, and that's why the entertainment industry and performances, performers and creative performance artists have been hit so terribly, terribly hard by this. It is an untested situation in the main at the moment, because there haven't been cases that have been challenged yet. There hasn't been a case of negligence like that, to my knowledge. There might have been, but there's no big public things going on at the moment, so we don't know which way decisions will go. The main legal guidance for the courts on looking at anything like this is about reasonableness. It's about, is the person more likely than not to be guilty or not guilty of the charged offence, you know, and is the person more likely or not to have been responsible for whatever the claim is that's coming at them. Cover your backs, really, really cover your backs. You know, as I say, go very carefully through everything, just like you would with any other risk. Just like if you entered into a ramshackle old theatre and you decided that you were going to take it on as a business, and you'd have to think about, you know, danger for people walking on a, you know, is the stage safe and all of those kind of things. Take those things into consideration. Don't forget those other things, because those things still exist. So that's important. But it just means that your risk assessment has got to be, well, it's got another ingredient, really. That's all.
Right. Okay.
Today, coronavirus is an ingredient for a risk assessment. Look at all those things and take those guidelines into consideration. If you didn't take the guidelines into consideration, it's not against the law to not consider them, but you're leaving yourself wide open to saying that you didn't take all reasonable precaution, you didn't look to check what your responsibilities were, and you went against guidance. You'd be kind of out on a limb if that were the case. So that's the thing. So assess the risks, assess all the risks, record the risks that you've assessed and how you look to minimize those risks. That's basic risk assessment procedure, people. But if you haven't done one before, you might want to consider doing one now and setting up policy within your organization for that. The other thing that you need to do now, because of the nature of this as a risk, is you need to make your employees or people who come in aware. And that's back to your point, Lee, about people signing a disclaimer. People need to be aware, if you haven't managed to totally eliminate the risk, which is unlikely you'll totally eliminate the coronavirus risk, people need to be aware of what the risk is that they're taking, as clearly as possible. And you also, for your own benefit as an employer, want to be making people aware of, you know, a process that they can go through if they don't feel safe, reassuring them. Maybe it's a good idea to set out some training, you know, to make sure that you've got a health and safety responsible representative within your organization, and to set out some kind of basic training. When I say training, I just mean making sure that people are aware of coronavirus risks and of risk assessment and so on, so that those things are done properly. That appointed person needs to be known. Again, their name needs to be on that risk assessment. And if that person isn't the person who's responsible for the business, the director or whatever, the director is responsible still for that person they've employed to do that, and that person should take all reasonable responsibility that they can, given their position, their understanding, their, you know, their situation as well.
Okay, so under that, would it be a good idea to say, quote the government's advice, or quote the government's vis, and say, you know, our government ministers are saying that there's a less than 1% chance of it actually affecting you?
I wouldn't recommend doing that, because that's speculation. It's not guidelines on following the law.
What the government are actually getting on
they
the TV
are, but
saying.
That's for people to personally absorb. If you put that into your business place and it turns out that the chance is 30% in your premises, you've misled people.
So what, the government are misleading people?
No, the government, and we're not going to do this, but what the government are doing is they're giving generalist messages to the population at large. They're not specifying businesses. And it's very important that you understand, if you are responsible for a business, that you have obligations that are not the same as everybody else's with respect to your business. You see, and that's important. So the advice about social distancing becomes so much more serious when you have a business and you are responsible for the well-being of the people who work for you.
So on the other side of the coin, what about now employees' rights?
Exactly. So I just want to say that there are posters and signs and things published by the government that you can put up and you should put up, because that will, about coronavirus and about hand washing. You also need to be very careful about toilets and those kind of conveniences, how you manage the people who clean them and keep cleaning safe. That's a particular risk area, as well as any tea, coffee making facilities and things like that. Just be aware of that. So get that risk assessment done and get it public, get it there. Make sure that people know what's happening. If possible, let people work from home if you possibly can. Okay. You have a sort of a duty really to do that as part of keeping people safe. If you can help them to work from home, you should. And that does bring us on then to employees. So obviously employees have rights as well. I have heard some stories recently which are a little bit alarming, where people have been told that if they don't come to work, they've lost their job basically. And they're being told that in a number of different ways. Trying to avoid making comments now about why I think that is, but they're being told that in a number of different ways, and it's not really appropriate. So if you're an employee who's saying that, I sympathize, I'm sure everybody would sympathize with the situation that you're in, because everybody's in a really, really difficult predicament, and the support for people, the financial support for people, seems to be being gradually phased out, or will be at least gradually phased out, I imagine. What speed, I couldn't comment. That's not law, and that's not for me to assert. I'm just trying to give you the facts so you can make your own minds up about what it means for you, and so on. But yeah, always good to get people to work from home. If you have a job where you work from home and you are feeling concerned about going back to work, you can say you're feeling concerned. You can express that to your employer. If you've got trouble because of childcare, you're entitled to take some time off to do that, but your entitlement is still unpaid in terms of that. Organisations, employers have been given support, government support, in order to furlough people, and in order to to support people through this and support themselves through this. And there's a whole number of business and self-employed things. I'm not commenting about whether they're adequate or they're not. That's not what this place is about, but they're there. So try where you can to kind of make an arrangement that fits within something like that. Bottom line is, if you have to go back to work, if you're expected to, and when you get there, you discover that your workplace has not got the right things in place to keep you safe, then you are perfectly within your rights to say, this is not a safe workplace. If you don't go into work because it's not a safe workplace, you'd be best if you could get some kind of, I don't know, photos, anything, some kind of evidence, some kind of statement from other people who work with you. Go through unions where you can, that will secure you, and they are the best way to do it. But ultimately, as far as the law is concerned, if your workplace isn't safe and you are dismissed because you refuse to put yourself in a place of risk, or if some of the practices and policies that are relating to you and your job are not safe, and you were dismissed for that, or disciplined for that, you could claim that it would be an automatic unfair dismissal under Section 100 of the Employment Rights Act. That's 1996. If you're dismissed for self-isolating, the same applies. And that, just in terms of bringing that up to date, the same would apply if you were contacted by the track and trace system to say that you must now isolate for 14 days because you've been in contact with somebody who has symptoms, even if you're well and have no symptoms. If your employment dismissed you for that, that would be automatically an unfair dismissal.
So,
and that means that you can get compensation from the, it's not worth it for employers to do that. So if you're an employer and you're listening to this, please be aware of that as well. I can't give individual advice on that right here and now because it's individual, but that's the case. So even if you're not sick, if you're home self-isolating, you should be able to claim statutory sick pay, and you can look up the amounts that would be. Lee,
so what happens then? What happens if, let's say, you've got your business and your employees are within the business structure, and one of them has the track and trace app, and they get told, "Oh, you possibly got the coronavirus. You've got to isolate for 14 days." But they've also been in contact with all of your employees. Now, does that mean all of the employees have got to go self-isolate for 14 days and you've got to shut down your business for 14 days? I mean, that's just...
No, I know it's not. It's not an ideal situation, is it? And we can all speculate as to how this might or might not go. A lot of people have been saying that they want this in place to feel safer. The system with the track and trace is that if you have symptoms of coronavirus and you are supposed to report them. If you don't have to have the app. You're supposed to contact the NHS track and trace system, which you can do online, or there's a telephone number that you can call. Watch the latest news updates for that. I didn't write down the telephone number, I'm afraid. But if you, that's what you would do. You would contact them, tell them you're being asked to do that, and to tell them that you have symptoms. And then to think about people that you have been within 2 meters of for more than 15 minutes. And that, again, balances slightly the issue about the workplace. So if you're an employer and that person who's got symptoms, for example, rings up and says, "Can't come in, I've got symptoms, I've got to self-isolate," it would be sick pay for them. If you have managed to socially distance your employees, you don't have to send them all home. The track and trace organisation will contact anyone that they feel has been with it after consultation with the person who's got the symptoms, will contact anyone that they feel has been within the 2 meter distance and therefore a high risk of having coronavirus or being infected by coronavirus for more than 15 minutes within that 2 meter distance. Okay, so again, if you're managing to socially distance that within your workplace, that kind of ensures you against that. And you know, that's kind of the best we've got, really. But what I'm also thinking about is a situation where somebody, an employee, might be contacted by the track and trace team and say somebody who's been in contact with you has coronavirus, and therefore even if you're well, you must self-isolate. You still have a right to self-isolate there. In fact, you have an obligation to. So your job cannot be on the line because of that. It would still come under the Employment Rights Act, Section 100, and that automatic unfair dismissal, in the same way as it would if you were sick, even if you're not sick, because it's on the basis of that contamination that you've been sent home. Nothing you can do about it. And in that case, you should self-isolate for 14 days. This is still guidance, the track and trace thing. I don't want to get onto this too much right at the moment because I want to deal with the law back to work issue. I will talk about track and trace as long as no major other thing comes up next week or between now and when I do the next video. I will talk about track and trace, and I will talk about the whole you know, restrictions to people's movement when they've been identified as contaminated under Schedule 21 of the Act. So if this is bringing up those concerns, I will deal with those next week. But at the time at which I decided to deal with this, it was the highest priority and the most questions.
Yeah.
Want to say one more thing. I know I've probably gone on for a very long time, but teachers, back to school, loads of concern there, loads and loads of concern there. One of the things that struck me, having been a teacher in a school myself, especially when we're looking at getting the little ones back to school first, is about control of the environment and health and safety. Again, and your responsibilities as a teacher. Who is going to be responsible if the children in your care, in your classroom area, or open learning zone, or whatever you've got in your school, actually, you know, cross those boundaries and get close to each other, or you know, the sort of 5-year-old who runs across the classroom, hugs their friend, then goes, "Oh, sorry," you know, it's done. Who is responsible for that? You are responsible as a teacher, obviously, for keeping the children in your classroom safe to the best of your ability, as you always were, for not being negligent. You are not responsible for the whole school health and safety policy and the workability or otherwise of it. You're not going to get sued if a child forgot and ran across the classroom, hugged another one, and they got coronavirus and the parents came after you. It would be the school that, you know, the head of the school that would be, or the principal, whatever, that would be responsible for that. Try not to get in a state about that. I know it's difficult. I know that this is going to present an awful lot of challenges for teachers. If you don't feel, and you feel that you can strongly make a case that your workplace is not safe with regard to your health and safety, not a safe place for you, you then have a legal right to make that case and to stay out of that unsafe place. We all have an obligation to keep ourselves safe and our children safe. Anybody now, not just teachers, but anybody who can't return to work because they're looking after the children. I think I covered that, didn't I? Repeating myself. Yeah, you got it right. Keep in contact with your employers, you know, and employers keep in contact with your staff. Let them know if somebody has gone off sick with coronavirus. Let them know what you've done to mitigate the risk, you know, to keep them safe. Let them know where they stand with regard to the guidelines. Try not to express your personal opinions. If you're in a workplace where you're working with other people, or where you're working with the public, with customers, be careful about expressing your personal opinions, because you could find yourself in a position where you've taken on a responsibility or excluded a liability of someone responsible for you without realizing you've done it, really.
Right.
So just keep your own counsel. It's a little bit like when there's a road accident and your insurance company says, don't take the blame. Talk to us before you talk to them. It's the same there. And on the subject of insurance companies, one thing I think I did forget to mention for employers, particularly again in entertainment industry, did I talk about liability insurance? Public liability insurance. I did. Didn't. Public liability insurance will be void if you were negligent.
Right. Yes, you did actually mention that. Yeah.
You've really got to watch it with your insurances. Make sure you've got them. Make sure you check them. Boring reading terms and conditions, I'm afraid, is going to come into the place a lot. If in doubt, go to the gov.uk website. Follow the guidance, people, when it comes to employment and looking after others. If you want to find more information, there's an amazing site that I found. It's called Monaco, MONACO Solicitors. So that's MONACOSOLICITORS, monacosolicitors.co.uk. And they have a free coronavirus rights app. Amazing. This is mainly for employees, it's got a whole load of letters and things and templates that you can use if you want to write to your employer, and you can download things. There's loads on there, and there's further advice. You can just click into it, and really, really fabulous specific advice for employees. So I'd say if you want something much more, kind of tailored, I'd say that's a marvellous place to go, and maybe go and look at that site anyway. Monacosolicitors.co.uk. What a godsend they are. I'm just looking at my little post-it notes that I've stuck all around my laptop to make sure that I haven't missed anything that was important that was in the questions. Oh, cafes and takeaways. Cafes, little restaurants and takeaways.
Mm-hmm.
Question kept coming up time and time again. Why are some, are they allowed to do, if they're doing a takeaway, can they not put a chair outside for people to sit down when they're waiting in their queuing system? What's the game with that? If you're running a cafe or a takeaway, and if you've been going to one and you don't quite understand what's going on, anything that counts as premises, i.e. land that they have a right to put chairs and tables on, counts as premises. If you are sitting down at the premises, they're encouraging you to, then that's classed as eating in facility. It stops it being takeaway altogether, even if you only perch your bum there having a bite of your burger while you're waiting for your friend in the queue.
Okay.
That is what it is. It's not about how many delivery drivers have touched it. It's not about the risk of coronavirus and per se, in itself. It's about an exclusion to the law that said they had to stay closed. They can open only if they're doing takeaway, and takeaway is not on the premises. Premises includes outdoor space.
Brilliant.
I think that's everything.
Yeah, thank you very much.
That
was
long, wasn't it?
We covered. No, it's okay. I mean, we covered it all in just over half an hour. That's pretty good.
Yeah, so, I'm just looking, just double checking.
Well, while you're double checking, if anybody needs to ask a question, please put it in the comments or on YouTube or on social media, as the videos will be going out, and we'll see what we can do. We'll cover as many as we can. Well, Karen will anyway. I mean, I'm just sitting in the chair and bouncing it off.
Because it creates kind of a balanced thing. It's not just like a dry old law lecture. I hope it's not, because that's the thing, isn't it? It's all a bit much, isn't it? And I'm trying to make it easier for people, not kind of bash their ears till they bleed. One other thing, if you'd love to come on here and join us and make another voice, and you've got a question, please get in touch. If you can't put any comments in the YouTube thing, if you haven't got a YouTube account or anything like that, comment in social media or wherever it is that you see this video or you see this video shared. We will pick that up, or you can message. I'm sure you're happy to receive messages, Lee.
Yeah,
I'm happy to receive messages. Please don't ask us, either of us, to talk about our opinion or to assert any kind of, or to make any assertions really about what something means outside of defining what it means in legal terms. The whole point is about staying completely non-biased, and that is so that you can get the clear information through the muddle. I hope to be like a kind of a fairly fat arrow through the muddle. And then you can make your own minds up, because you're bright people, you can work out for yourself what you believe in, but you just can't get at the facts these days through all everybody's opinions. So that's why we're doing it this way.
As challenging as that is.
It is really challenging. Yeah, it's really challenging. And some things, I think we've got the same views on. Some things, our views are probably wildly different, whatever. But as soon as I start giving an opinion, it starts to get mixed up with my advice. And then it ends up looking like everything else that's out there. This is what's missing, and this is why we're doing this. You can find this sort of information online, but it's written, and it's usually written by barristers and solicitors firms. But that Monaco Solicitors is good. Okay, I'm going to stop talking. That'll be
okay. So please, if you like the video, please click like, share it. Hit the notification bell, subscribe. Brilliant.
Let us know if it's helpful for you as well, because that feedback would be really good for us. Let us know what you liked. If there's anything you didn't like, just let us know, please.
Anything you want us to cover?
Yeah.
That's it.
Yeah. Thank you. Thank you very much.
Thank you.
Thanks. Bye-bye.
See you soon.
Bye. See you the next one. Oh, next one. Yep. Next one soon.
soon.
Okay. Thank you.
Yeah.
Bye.
Bye-bye.